What's going on? I've got a bunch of clips from Judge Clark's docket today. We're going to start with an epic pro se fail. Now, there are 2 or 3 pro se cases on this video, and one kind of interesting hearing. But the first one, man, oh man, you bring attitude to the wrong judge, especially when you're pro se. Judge Clark doesn't play that. Anyways, I'm Colin. We're cooling. Let's go.
Mr. Bowden, you're before the court today. You're representing yourself. I don't really know what you're going to tell you what I'm going to do.
Say it again.
I don't know what we're here today for on your stuff, but what I'm going to do today
It's supposed to be for the Richardson hearing.
Sir?
Richardson hearing.
We're not having a Richardson hearing today. Yeah, but hold on just a second. All right. Mr. Bowden, you're representing yourself. Since you've represented yourself I filed a motion November 6th, and again, you have filed 83 separate filings between August 22nd of 2025 to November 6th, 2025. I indicated at that time, it's the third time I had advised you that you have a right to represent yourself, but it only goes so far. And it's up to me whether I can determine whether you can still represent yourself. Since that order, you have filed 1, 2, 3, 4, 5, 6. No, hold on. 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12 motions. Most of them nonsense. So what I'm going to do at this time is I'm going to find that you're not competent to represent yourself. And on one of your last filings, you indicated if I did appoint an attorney, you would intervene.
I don't want nobody to represent me because you did that, and I have that.
Listen to me. You're not talking right now. I'm finding you're not competent to represent yourself.
You can't find I'm not competent. I've been found.
I've already found you're not competent, and I'm changing my mind.
We're just going to have to go a long way with this then.
I'm appointing the Office of Public Defender to represent you.
I got a conflict with them, and we're just going to go the long way.
It's up to them whether they have a conflict or not.
Well, we're going to go the long way then.
I'm going to enter a not guilty plea on your behalf on the amended information. That will conclude your hearing today. Y'all can go ahead and take him in the back.
And hey, that's just what it is. But like, remember, you called me a nigger off the record.
That'll conclude today's hearing. We got a sign-in sheet.
Yeah, that was a short one. I had to play that. Oh, man. What did he call him off the record? Oh, I heard him. I just didn't want to say it. I highly doubt Judge Clark did that. Yeah, especially not in the courtroom. That'd be weird. Anyways, 86 motions in just a couple of months. Really, dude? Really? Most of them nonsense. I want to know what percentage of them are not nonsense. How many motions did he file that make sense? I don't know. Maybe a motion to represent himself? I have no idea. Anyways, that one, yeah. I've got no words. So we're just going to run through the rest of this. I got 3 more. We're going to go to an actual Richardson hearing where we have an attorney who is trying to throw the prosecutor under the bus for not getting a video that his client told him was available, which is a weird process. It's a weird step to take, right? A defense attorney just 100% believing his client that this is available and then scheduling a Richardson hearing. Okay, let's go.
All right. This is a motion for a Richardson hearing and sanctions. Whose case is this?
Mr. Jackson Bate.
All right. I've reviewed the motion. Mr. White, the state's response.
I'm sorry, Your Honor, I didn't hear him.
Say that, pull that microphone over, Mr. White.
Right. The issue in the case is over a video of this incident. This incident occurred in 2022. There was an outstanding warrant in this case that was not served until this year. Because of the age of the case and the time of this original incident, to my knowledge, we have requested the video and we have not received it. And as far as I'm aware, there is no video that exists in this case any longer.
All right. All right, sir, your response?
Your Honor, there was a video there. This was going on before. It was in the possession of the, as I understand it, it was turned over to them. Now he's saying it doesn't exist. It was in the possession of the state.
To my knowledge, we do not have this video.
Okay, but that's different than it didn't exist, Judge. They lost it. And it's exculpatory because it has another individual on there that is not my client fighting.
Who lost?
If the state had it in their possession and they don't have it now, my argument is that they lost it.
Is there any, who told you the state had it? Mr. White's indicating they don't have it.
My client, before I got on here, we had discussions about it. He was going to go look for it. I didn't. The place where they were at had that video. It was asked for.
Wait a minute. Hold on just a second. The case was filed April 11, 2022. A warrant was issued on April 11, 2022. The warrant was executed on March 2nd, 2025.
Okay.
What video are you talking about?
The place where the fight supposedly took place,
it was a business or something, somebody else's video. Is that correct?
Yeah, yes, sir.
All right, who took it into possession?
Okay, I mean, I don't want to get this wrong. The police, when this was going on, took it into possession. When Mr. Brandon Matheson called the police on this.
How do you know that?
That was through discussions with my client and the individual that's on that tape. That's not my client, has reached out to me and told me that it was videotaped.
Mr. White?
Your Honor, I've sent a request to our investigator and we have not been able to obtain this video. As far as I'm aware, we never collected this video.
Your Honor,
regardless if law enforcement collected the tape, if the state attorney's office doesn't have the tape, is that a Richardson violation?
Your Honor, I'll answer your question this way. The individual that's on there, that his name is Seth Kearney. I'm sorry, his name is Kent Kearney. That's the guy, that's the gentleman that actually knocked the phone out of Mr. Brandon's hand. He's the one that told me. I've given Mr. White the contact information for Kent Kearney, the person that is there. I've made them aware. Nobody's contacted him.
Your Honor, the offense report in this case indicates that the case agent was able to review the footage, and the footage that was available at the store did not show this incident.
Your Honor, I don't have that footage.
It was never collected.
Well, Your Honor, I'm entitled to that information now.
You're not entitled to it if they don't have it.
Judge, if they don't have it, and I would have saved the court time. Their possession is it was never collected. They reviewed it, it's on there, and so I thought that because if they're reviewing it, it's in their possession. That was my conclusion. So if they're saying it was never taken into evidence, it's different. You're right.
Thank you. That's the state's position, is that it was never taken into evidence.
Yes, Your Honor.
Judge, that's the first I heard of that. I'm sorry I wasted the court's time.
Okay, we need another court date for Mr. Jones.
He's on the February 2nd jury trial.
All right, we'll leave that set, and we'll set it for January 23rd at 1:30. January 23rd at 1:30 for a trial management.
So if this was never collected, they just left it at the place, or because I can't get them to answer it.
Mr. White, Mr. White, if you'll get to a microphone, that's your representation today. Is that correct?
I can't hear it, Judge.
He hasn't
Yeah.
said anything yet.
Yes, Your Honor, that is the state's position.
All right.
Judge, thank
Anything
you.
else?
No, thank you for your time.
You convened.
Yes, sir, that'll conclude the hearing.
I've got Bradley Williams. Your Honor, this is Bradley Williams in case 241657. I got a progress report from Life Management dated November 18, 2025, and have reviewed that.
I've reviewed the one that was filed on October 21st. No, when was it filed? No, November 18th, and it doesn't appear that Mr. Bradley has been cooperative. So what I'm prepared to do is I'm going to appoint another expert and to make the determination whether Mr. Bradley is, if he's not amenable to any out of hospital or competency restoration, that I'm going to find out if the Florida State Hospital is the least restrictive measures.
Your Honor, with all due respect of you and the court.
That means I have no respect, but go ahead.
I've been trying to comply with the competency people. They requested, after the first time that they came and visited me, they said that I failed because I didn't know how much time my sentence carried in court. Now I know that my third degree felony carries 3 years or 5 years prison.
No, that's the issue with that is you need to, I've already found that you're incompetent to proceed. I can't go any further in your case until I can find you competent to proceed.
Yes.
What they're saying is that you're failing to refuse to comply with what Life Management is trying to do.
They have failed to work with me, sir, because they want.
I know, Judge. Words are hard. Failing to refuse to comply. That's on the record. I know it's not what he meant. He tripped over his words, but I do that all the time. I feel vindicated for some reason.
Wanted me to sign up for a ulterior program through Life Management, which was not court ordered, sir. They was trying to force my hand to sign this paper, and I didn't want to join that program. I wanted to continue my competency. And when they came the second time, they asked if there was a reason why I didn't want to sign up for it, and I said I believed that it was not necessary. I said that I just wanted.
Let me just stop here. What is the jail diversion program? Anybody aware of that?
All I saw was on the paper.
We have a representative from Life Management.
No, sir, they're not here.
Yes, sir. Judge Clark.
What is this? What is the jail? What is the LMC? What is the jail diversion pilot program?
The jail diversion pilot program is a program that diverts clients or prisoners from going to the state hospital. Once they're in this program, they're able to receive services with us even after they are discharged from jail or the Florida State Hospital.
Is it something new, or is it something that's what Life Management's always done when I've ordered restoration in the jail or restoration in the community?
So for some of the clients, even though they're deemed incompetent, if they seem like their behavior and all of those things are together, we divert them to the jail diversion program, and that keeps them from going to the state hospital and continue to do their competency sessions. But without that program, if they come into the sessions and they continue to not do the competency sessions, then more than likely they're going to go to state hospital. And that's what I was trying to explain to him on the other day.
Your Honor, when they came in and talked to me about the program, I told them I didn't have any belief that we would not be able to continue with the competency and that I would fail because it was said they was coming to work with me every week. Well, they said that They came in the following time. This was the third time they visited me. Still no progress on the competency. She brought in her advisor or her superior, and they said that if I didn't sign the paper, that they would be able to send me to a mental hospital for a very long time, is what they had said. Now, we was in the multipurpose room, and I asked them, I said, is this a threat? And they said, no, it's a promise. A very agitated and very forward towards me. And I asked if the conversations were recorded because I felt for my safety at the time, as my word would not be taken as legitimate. And they continued to harass me about asking if the conversation was recorded. Soon afterwards, I was told by a member that was in the jail, another inmate, that they was talking about my case while he was in there. That's a breach of confidentiality on all parts. They continued to heckle about it and say, can you believe that boy asking if this conversation is recorded? Well, after that conversation, I asked if it was recorded. They said that they would see me at court. Well, she came in yesterday to talk to me and actually to try to start doing the competency program. And we got into a discussion. She said that I was irate and agitated. I received a DR, and I would say at least 60% of this DR is fabricated. I would request the video surveillance from the room, and if her testament right here in the DR is false, I would like an investigation with life
All
management.
right, what I'm going to do is I am going on my own
Judge,
motion. Yes,
okay.
ma'am.
Yes, I would also like to say that Bradley thinks that if he's not standing up or irate, that that's not still being combative. The issue that I'm having with him is not doing the competency sessions. He wants to come in every session and pretty much discuss his case, why he shouldn't be there, why he's not incompetent. All of these things have nothing to do with competency sessions or competency restoration. I have no issue doing the competency sessions with Bradley, but the combativeness every time we meet up, that's something that I can't deal with as a therapist because
All right,
that's
what I'm
not
going to
what
do.
competency restoration
Yes,
is
ma'am.
about.
Yes, ma'am. I understand. What I'm going to do is I am on my own motion, though, sir. I've had enough. I'm going to appoint another doctor to examine you and to see if you're amenable to community-based restoration. If not, if there's what's the alternative, I'm going to set you for a hearing January the 19th at 9 o'clock. Good luck. But you're to continue with your restoration if you're able to.
Can you allow a second for me to talk to my public defender?
It's not going to have, you can talk to her and she'll talk to you, but it has nothing to do with what I'm doing right now. I've already made my ruling. Have a
Have
seat.
a seat and I'll come over and see you in a minute. I'll come see you in a minute.
January 23rd. Yes, I'm sorry.
Give me a
January 23rd.
Your Honor, I have Jeremy.
All right, three down, one to go. Hopefully you guys are enjoying this video. I will take the minute to say right now, please hit that like button if you are. Subscribe, hype, comment, do all those fun things. You know what to do. Let's watch the last one. We have another pro se. This one actually doesn't do as bad as the rest of them. He's a little bit more competent than the others. Let's go.
Your Honor is out of custody, so just let me know when you're ready.
Okay. Mr. Ballard, need to step out. All right, let's take Mr. Davis. That's the state of Florida versus Anthony Joseph Davis, 25 CF 2402, 25 CF 2420. Mr. Davis, found that you're competent to represent yourself. Do you wish to still represent yourself?
Yes, sir, I do.
Okay. I've my office set the hearing. The state has filed a traverse on the motion to dismiss.
I haven't received a copy of that yet.
Yeah, I think it was just filed. So we'll provide Mr. Davis with a copy of that. That's 25 CF 2402.
I can provide him with a copy of the traverse in 02, response to the motion in limine in 2402. Can you please print a motion in limine in 2420? Thank you. There's the traverse. 2420, yes, ma'am. Just so the court's aware, the case number on the one filed in 2402, or let's see, you have motion limiting 2402. All right, yeah, so 2420.
All right.
It's essentially the same response because it's the same motion.
All right, so that takes care of the motion to dismiss. Let's see.
Do I get a response, being I ain't had a time to look over either one of these?
You can look over, once the state traverses us.
Yeah, it's automatic.
It's automatic, but you can certainly look at it.
All right, I'm good. We can move forward.
Mr. Davis also has several demands for discovery that are filed. I forwarded those demands for discovery to our investigator. They are being worked on. I noticed that specifically he requested the names of what basis of his motions in limine were based off the fact that the identification used in this case, it was at least the Walmart case, was based upon someone reviewing the videotape, which means that the prior special familiarity doctrine applies. And there were people at the sheriff's office and at the Beach Police Department who had prior relationships with the defendant who did help identify him, and they were not named. They were not in the original offense report, and he requested that information. I found the name of one of them, and I believe it's Sergeant Rose with the Beach Police Department, and we're going to be sending you an updated discovery worksheet.
Yeah, I haven't never even received a formal, like the formal discovery exhibit from the state.
I also have, let's see.
Your Honor, just to make this a little easier, I'm gonna give him a copy of both the public record responses from the Panama City Police Department with the CAD report, the hourly body cam footage on it, the case coordinates. And the only other thing that I was asking, Mr. Jackson, Mr. White is correct, as I was asking for the audio video of when the Walmart asset protection team, Francis Toro, actually found the condition of the doors. All right, the video that I sent you and asked you to review, the officer escorts them at 6:56 something that afternoon, where she said she had discovered it that morning, and they go to a set of doors that are locked, and that's been I would say tampered with from its original state that she alleged that she found it that morning. All right, during the video with the 12-minute clip, there's an individual that goes to the left-hand door numerous times. The state is correct on that. But the right-hand door is never accessed, and it's the same damage to both doors. Do you understand what I'm trying to say?
I think so.
And that's what I'm asking for, the video as she found it that morning, because there is nothing. You hear me? She's saying that she found it in the state, but at 6:30, 6:50 in the afternoon, her hair is wet, like she just come in from a shower and reported to work that day. You hear me?
All right, Mr. White.
Your Honor, we had the witness testify in the
Adversarial hearing.
yes, Your Honor. I've also traversed that. I would be happy to review the body cam footage and also go through the surveillance footage again.
Yeah, because
But I think that the proper purview of the issue would be for a jury to decide and not for a motion to dismiss.
All right, let's do this. You're still working on discovery,
right
today.
Yes, I do have, we did request or obtain the surveillance, body cam and surveillance videos from the 20 case, which is from the Holiday Inn Express. I'm providing this disc to the deputy. We'll make sure that you obtain a copy at the jail, and we're continuing to work on getting the names. I'll send you over an updated discovery supplemental, which will include the names of the people that were used to identify you.
all righty.
All right, you've also filed, and this is the Justice Administration Commission has responded to your motion to
For the fire safety inspector.
Yeah, and they've objected, so we need it. If you want that, we need to set that for a hearing also.
This is my thing right here, Your Honor. I know he traversed the motion. Statutorily speaking, this what he's calling the fire alarm is not a fire alarm. The building could burn down outside of it, and that alarm would still be. The alarm only functions when the door is open. That is it. That is it, and it's not statutorily. it's inapplicable to 806-10-1. And the case Robinson that I supplied in the motion to dismiss, it distinguishes that because it identifies a smoke detector, it identifies a fire extinguisher. Those are equipment used in suppression.
Well, I haven't had a chance to review the Traverse either, so
All right.
we'll review that also. And like I said, as far as, do you want to set a hearing on your motion to incur cost?
Yeah, yes, sir, if you would, please.
We'll set that on the 19th.
And can you, would it be too much to get a discovery cutoff date? I know it,
December 18th.
yes, sir.
Okay.
Appreciate you.
Yes, sir.
Thank you. You have a good Thanksgiving too.
All right, is Mr. Ballack still out?
All right, that's it. We've seen that guy before. A couple of months ago, I remember asking the question, how was he charged with a fire alarm? It wasn't. He wasn't charged with a fire alarm. They worded it weird. I don't remember what it was. I don't. Anyways, hopefully you guys enjoyed the video. I already told you guys to like it. You know what to do. But that's it. That's all I got. Till next time. Bye.
I went down the hallway. I don't know where you
See, Mr.